Hi, uh, welcome again to Basic Philippine Laws Books channel. Our topic for today is void and voidable marriages. Okay, let us start with void marriages. From the start, I want to emphasize that what makes a marriage void or voidable would be the absence of either the essential or formal requisites. If that is the case, it would make the marriage void. Okay. Uh, and what makes a marriage voidable? It is a defect in any of the essential requisites. Okay. So these defects or absences of the essential or formal requirements would result in either a void or a voidable marriage. Let us start with Article 35. Article 35 tells us that the following marriages shall be void from the beginning: those contracted by any party below 18 years of age, even with the consent of parents or guardians. We all know that the age of majority in the Philippines is 18 years of age, and part of the capacity, the legal capacity of a person to enter into any contract, including the contract of marriage, is the legal part of the legal capacity is a person should be of the age of majority. Okay. Number two, those solemnized by any person not legally authorized to perform marriages unless such marriages were contracted with either or both parties believing in good faith that the solemnizing officer had the legal authority to do so. As you all know, authority of the solemnizing officer is one of the formal requisites of for a marriage to be valid. So if the solemnizing officer had no authority, then the marriage would be considered as void from the beginning, except in cases when either or both parties believe that the solemnizing officer had the legal authority to do so. So if there is that belief that that person, even though not legally authorized to perform marriages, okay, the parties, either of them or both of them, believe that he had the required authority, the result would be uh, a valid marriage. However, it may subject the solemnizing officer to any disciplinary sanction. Okay, number three, those solemnized without a license, except those covered by the preceding chapter. We all know that a valid marriage license is one of the formal requisites for a marriage to be valid. And if the marriage license is absent, okay, then it would result in a marriage which is void ab initio unless the marriage falls within any of the exceptions to the requirements of marriage license, such as marriages in the point of death, marriages in remote places, or ratification of marital cohabitation. Okay. Number five, number four, I think, those bigamous or polygamous marriages not falling under Article 40. So if the marriage is bigamous, meaning there is already a valid and subsisting marriage, and then you entered into another marriage during the subsistence of the previous marriage, it would make the marriage bigamous. Okay, what is the lacking requisite? The essential requisite of legal capacity, because there is a legal impediment to enter into another marriage. Okay, so bigamous or polygamous marriages are void from the beginning. Number five, those contracted through mistake of one contracting party as to the identity of the other party. So, of course, the classic example for number five is when you are marrying a person. Let us say, for example, the wife, the bride had a twin sister. Okay, then and you're marrying not the person that you intended to marry, but the twin sister of that person. So that was contracted through mistake. Why is a marriage contracted through mistake as to identity considered as void ab initio? Because there is absence of consent. Because if you had known that that person is not the person that you're intending to marry, then you would not have entered into the said marriage. So the essential element or the essential requisite of consent is lack. And last, those subsequent marriages that are void under Article 53. So later, we will discuss these are marriages in which there is a previous marriage. Okay, that marriage was already dissolved uh, either by death or annulment, and then you enter into another marriage without liquidating first the community property in the previous marriage. It would have an effect on the subsequent marriage, declaring the same as void. Okay, now, Article 36, this is, as I have said before, when you become lawyers, as I have said in my uh, classes, the lectures in my classes, if you become lawyers someday, this is the most, one of the most lucrative areas of practice. Okay, declaration of nullity of marriages on the ground of psychological incapacity. Now, what is Article 36? Article 36 tells us that a marriage contracted by any party at the time of the celebration was psychologically incapacitated to comply with the essential marital obligations of marriage shall likewise be void, even if such incapacity becomes manifest only after its solemnization. You must remember that psychological incapacity um, is one of the grounds to declare a marriage nullity because one of the essential requisites of marriage can be considered as absent. Okay, what is that essential requisite? That essential requisite is consent. Because if you had known that the person that you are about to marry psychologically incapacitated to comply with essential marital obligations, of course, you would not have given your consent. So one of the essential requisites of marriage, which is consent, is supposed to be absent. So that is the reason why the family code declares that if you have married a person who is psychologically incapacitated, that marriage is void ab initio. It is actually in the Philippines, considering that we have no divorce, okay, this is actually the nearest to divorce that a person can, a person who wants his marriage tie to be severed can avail of. Now, what is the distinction between a void and a voidable marriage? Okay, a void marriage, a marriage which is void from the beginning, it can never be ratified. Okay, so even if you uh, know the defect or know the absence of the said requirement and you still continue with the marriage, it does not change the fact that the said marriage is void. Okay? Uh, it is always void. It does not change its nature. It can be attacked directly or collaterally. So a void marriage can be challenged not only in a direct proceeding to nullify the marriage and make it void ab initio, it can also be attacked in other actions, which is not instituted directly to nullify the marriage. Example, an action for support or even an action to nullify a donation. Okay, a marriage can be attacked also in those actions, even if they were not filed directly to nullify the marriage. Okay, and another important distinction that there is no absolute community, only co-ownership. We will discuss that later when we go to property, unions, um, persons who are not married. Okay, voidable marriages, okay, they can generally be ratified by free cohabitation. So, for example, if there is defect in consent, like for example, there was fraud, okay, when a person entered into marriage, okay, free cohabitation will validate, okay, the said marriage. If, for example, they have lived notwithstanding knowledge of the fraud, they still live together, and the corresponding prescription period to file or to challenge the validity of the marriage has already lapsed, then it can be said that it was already ratified. Okay? It is valid until annulled. Okay, so until an annulment of marriage has been filed and has been granted by the court, the said voidable marriage is still considered as a valid marriage. Number three, it cannot be assailed collaterally. There must be a direct proceeding. So there must be an action which is filed directly to challenge the voidable marriage. It cannot be attacked in any other action, such as an action for support or any other action for that matter. Okay? Fourth, there is absolute community. Okay? Unless, of course, the parties have agreed on another property regime. Okay. Pulido versus people, we have discussed this previously in the previous meetings. Okay, of course, Polito versus people is an action, is a criminal action for them. So in this case, the Supreme Court held that even after a person or the accused has already been convicted of bigamy, if later on in another action, in a civil action, to nullify the marriage, the said marriage was declared as void from the beginning, even if the accused has already been convicted and has already the case is already on appeal. Okay, the accused can be allowed to use that declaration of nullity as a defense in the bigamy case. Okay, the Supreme Court found it appropriate to declare in the case of Pulido versus People, we hold that a judicial declaration of absolute nullity is not necessary to prove a void ab initio prior and subsequent marriages in a bigamy case. Consequently, a judicial declaration of absolute nullity of the first and or second marriages presented by the accused in the prosecution for bigamy is a valid defense, irrespective of the time within which they are secured. Thus, an accused in a bigamy case should be allowed to raise the defense of a prior ab initio marriage through competent evidence other than a judicial decree of nullity. Okay, so it can be presented even in the criminal case. Okay, okay, we have the case of Castillo versus Castillo. Okay, in this case, Renato filed a petition for declaration of nullity of marriage, praying that his marriage to Leia be declared void due to her subsisting marriage to Bautista. So it is another case of bigamy. Okay, Leia opposed the petition and contended that her marriage to Bautista was null and void as they had not secured any license. So in this case, the RTC declared the marriage void ab initio on the ground that it was a bigamous marriage. The RTC stressed that so long as no judicial declaration exists, the prior marriage is valid and exists. Okay, so you must remember that in the case of Castillo, this was a marriage which was still under the civil code. At that time, the family code is not yet existing. So the civil code contains no express provision on the necessity of a judicial declaration of nullity of a void marriage. A judicial declaration of absolute nullity of marriage is now, however, expressly required where the nullity of a previous marriage is invoked for purposes of contracting a second marriage. So under the family code now, okay, it is needed that you have to secure a prior judicial declaration of the nullity of your first marriage before you can be allowed to enter into another marriage. A second marriage contracted prior to the issuance of this declaration of nullity is thus considered bigamous and void. The nullification of a marriage for the purpose of contracting another marriage accomplished merely on the basis of the perception of both parties or of one that their union is so defective with respect to the essential requisites of a contract of marriage as to render it void ipso jure and with no legal effect and not before. For such a socially significant institution, an official state pronouncement through the courts and nothing less will satisfy the exacting norms of society. So in the case of Castillo, the second marriage was entered into in 1979. The first marriage of private respondent being void for lack of license and consent, there was no need for judicial declaration of nullity before he could contract a second marriage. In this case, therefore, we conclude that private respondent's second marriage to petitioner was valid. Okay, again, let me remind you that Castillo was decided when the civil code is still in effect, meaning there is no need for a prior judicial declaration of nullity. Okay, as long as any one of the essential or formal requisites are absent in your first marriage, then you can consider it as already void ab initio. Okay. We have the case of Malaki versus people. Okay. This is again another case of bigamous or polygamous marriages, void marriages on account of the same being, bigamous or polygamous. Okay, this case is about a convert of Muslim. They were previous Christians. Okay, he contracted two marriages, civil marriages. When he contracted the second marriage, after contracting the same, in order to prevent prosecution for bigamy, he converted into Islam on the ground that under the Islamic religion, a male persons can contract two or more marriages provided that he can equally provide for all of his families in the said marriages. Okay. So in this case, a party to a civil marriage, the Supreme Court held that a party to a civil marriage who converts to Islam and contracts another marriage, despite the first marriage's subsistence, is guilty of bigamy. Likewise, guilty is the spouse in the subsequent marriage. Conversion to Islam does not operate to exculpate them from criminal liability. Okay, so what are the facts of the case? So in this case, Miriam married Francis on March 26, 1988, under the religious rights of the IFC. Now, in 2005, Francis left, okay, and abandoned his family. Later on, Miriam discovered that Francis was cohabiting with Jacqueline and that they contracted marriage on June 18, 2005 before a municipal trial court judge. Okay, so you must remember that both marriages, the first marriage was under the rights of the IFC, the second marriage was a civil marriage before a trial court judge. Now, Francis and Jacqueline admitted that they got married while Francis' marriage to Nerian was existing. However, they claimed that they could not penalize for bigamy as they converted to Islam prior to their marriage. Now, the issue in this case is whether or not a party to a civil marriage who converts to Islam and marries under the Muslim code is exempted from criminal liability. Okay, the Supreme Court is speaking through a Senior Associate Justice Yonen said, the civil code governs marriages not solemnized under Muslim rights, including those between a Muslim and a non-Muslim. Crimes and offenses in connection with civil marriages are defined in the revised penal code and special laws. The general rule is that a married Muslim cannot marry another. However, in exceptional cases, the male Muslim may do so if he can deal with them with equal companionship and just treatment as enjoined by Islamic law. In other words, the consent of the wife or the permission of the wife is a condition with respect to subsequent marriages. So in this case, the wife did not consent. In fact, she even sued Francis for bigamy. So to this day, the Philippine outlaws divorce for its non-Muslim majority. A contemporary practice in the Philippines has been observed where males convert to Islam as their alternative to divorce. Conversion to Islam to remarry and circumvent the laws on bigamy generates legal tensions as it exploits the protective mantle of religious freedom under the Constitution. A Muslim man who shall knowingly contract a subsequent marriage without complying with the conditions set forth under the Muslim code cannot claim exemption from liability for the crime of bigamy. So, in this case, there was no consent of the wife to the second marriage. And another reason is that it is not the Muslim code that governs them, but it is actually the civil code because they were married under civil rights and they converted to Islam only after the contracting of the second marriage. Therefore, the court held that the petitioners are guilty of bigamy. Okay, so now we go to the cases discussing Article 36 or psychological incapacity. Let us start with the Republic versus Molina because Republic versus Molina laid down the first guidelines on how to interpret and apply Article 36 of the Family Code. In Republic versus Molina, the following guidelines were laid down. Okay, in determining whether or not the party can be considered as psychologically incapacitated pursuant to Article 36 of the Family Code. First, the burden of proof to show the nullity of the marriage belongs to the plaintiff. Any doubt should be resolved in favor of the existence and the continuation of the marriage and against its dissolution and nullity. So that is the first guideline. So the burden of proof is on the plaintiff. So the plaintiff must prove that the respondent is indeed psychologically incapacitated. And if there is doubt, okay, the court will always resolve it in favor of the validity of the marriage. Okay. Second, the root cause of the psychological incapacity must be medically or clinically identified, alleged in the complaint, and sufficiently proven by experts and clearly explained in the decision. So, the root cause of the psychological incapacity is required to be established by a psychologist or a psychiatrist. Why? Because of the requirement in Molina that it must be medically or clinically identified. So a lay person is not equipped with the necessary technical expertise to establish the requirement of the root cause of the psychological incapacity. So that is the reason why declaration of nullity cases under Article 36 became expensive because there is a need to hire the services of a competent psychologist or psychiatrist. Number three, the incapacity must be proven to be existing at the time of the celebration of the marriage, although the illness need not be perceivable at such time. So the requirement of juridical antecedents. So meaning that it was already there. The psychological malady or the psychological aberration must be existing before the marriage, okay, and not thereafter. So it may manifest after the marriage because it is the time when the couple have already lived together and shared the same room. Okay, but the incapacity must be established to be existing before the marriage. Okay, so the requirement of juridical antecedents. Okay, number four, such incapacity must also be shown to be medically or clinically permanent or incurable. Such incurability may be absolute or even relative only in regard to the other spouse. So the incurability also must be established. And again, the person or the witness who could competently testify on the incurability of the psychological incapacity should be the psychologist or the psychiatrist. Why? Because it should be shown to be medically or clinically permanent or incurable. So just like the root cause, the incurability must also be medically or clinically permanent as testified to by the psychologist or the psychiatrist. Such illness, number five, must be grave enough to bring about the disability of the spouse to assume the essential obligations of marriage. So mild characterological peculiarities, mood changes, occasional emotional outbursts cannot be accepted as root causes. The illness must be shown as downright incapacity or inability, not a refusal, neglect, or difficulty, much less ill will. In other words, the psychological incapacity as laid down in the seminal case of Santos, okay, states that it should not be confined, okay, to cases of mood changes, occasional emotional outbursts. It is only confined to the most serious cases of personality disorders. Okay, the seminal case of Santos confined psychological incapacity to the most serious cases of personality disorder. If it is merely irreconcilable differences, okay, or conflicting personalities, or irresponsibility, or um, mood changes, or occasional emotional outbursts, these are not the psychological incapacity contemplated under the law. It must be the downright incapacity or inability, not a refusal, neglect, difficult, or ill will. Okay? We have the case of Tityangkin versus Tityangkin. Okay. In cases of psychological incapacity, the facts are very important. Okay. In this case, Eduardo and Elena got married. Okay. During the first few months of their marriage, they lived harmoniously. However, after a year, they started having fights. Okay. Sometimes Eduardo would sleep over his grandmother instead of going home to his wife. Okay? Every time Eduardo left their conjugal abode, Elena would fetch him and bring him home and they would settle their differences. Okay? When Eduardo left their conjugal home, there was a time Elena did not anymore fetch him. They lost communication. And Elena eventually found out that Eduardo was having an extramarital affair. And then, eventually, they separated. Now, Eduardo filed a petition for declaration of nullity of his marriage under Article 36 of the Family Code. Now, Dr. Tayab, the psychiatrist, found Eduardo to be uh, afflicted with passive-aggressive personality disorder, while Elena was suffering from narcissistic personality disorder. For her answer, Elena claimed that she was a doting wife to the petitioner, that she had already forgiven him, and that she was willing to welcome him with open arms should he decide to return and live with her. Now, the RTC denied the petition and dismissed the complaint, but the same was reversed by the Court of Appeal. So the annulment or the declaration of nullity was granted by the appellate court. Now, the Supreme Court said that to warrant a declaration of nullity on the basis of psychological incapacity, the incapacity must be grave or serious, such that the party would be incapable of carrying out the ordinary duties required in marriage. It must be rooted in the history of the party antedating the marriage, although the overt manifestations may emerge only after the marriage. And it must be incurable, or even if it were otherwise, the cure would be beyond the means of the party. So in this case, the totality of evidence presented failed to prove sufficient factual or legal basis to rule that the party's personality disorders amount to psychological incapacity. The court finds that the incapacity of Eduardo is premised not on some debilitating psychological condition, but rather from his refusal or unwillingness to perform the essential marital obligations. It, mere difficulty, again, the court emphasized that mere difficult refusal or neglect in the performance of marital obligations or ill will on the part of the spouse is different from incapacity rooted in some debilitating psychological condition or illness, irreconcilable differences, sexual infidelity or perversion, emotional immaturity, and irresponsibility, and the like, do not by themselves warrant a finding of psychological incapacity. What is evident from these circumstances is that while the alleged personality disorders of Eduardo and Elena made it difficult for them to comply with their marital duties, the same did not make them psychologically incapacitated. Psychological incapacity must be more than just a difficulty, refusal, or neglect in the performance of the marital obligations. It is not enough that a party prove that the other failed to meet the responsibilities of a married person. A mere showing of irreconcilable differences and conflicting personalities in no wise constitutes psychological incapacity. These differences do not rise to the level of psychological incapacity under Article 36 and are not manifestations thereof. So you must remember that for it to be considered a psychological incapacity, it means non-cognizance of your obligations as a husband or as a wife. Okay? If you knew the said obligations, but you find it difficult to comply with these obligations, or you neglect to comply with these obligations, then that would not be psychological incapacity. That would make a marriage void ab initio. Okay, so that is what is important to know with respect to the case of Dick Chang Hee. Okay, we now move to the case of Gantan versus Gantan. Okay, in this case, she first met the respondent in 1999 and she was only 19 years old. They were married twice by civil rights, and later on, uh, their relationship was all rosy during the courtship stage, but it eventually became a roller coaster ride after they got married. Okay, this is a case wherein the wife was repeatedly physically abused. Okay, one time he severely beat her up, causing her to be hospitalized, and she even suffered a miscarriage due to his fits of anger. He was also verbally and emotionally cruel to her. So, Dr. De La Cruz diagnosed the respondent with antisocial personality disorder, characterized by a pervasive pattern of disregard for and violation of the rights of others. Again, the Supreme Court emphasized psychological incapacity refers to a mental incapacity that causes a party to be non-cognitive. Must remember the key word non-cognitive of the basic marital covenants, which must be assumed and discharged by the parties to the marriage. The law has intended to confine psychological incapacity to the most serious cases of personality disorders that clearly demonstrate an utter insensitivity or inability to give meaning and significance to the marriage. It is the inability to understand the obligations of the marriage as opposed to a mere inability to comply with it. Again, I will repeat, psychological incapacity is the inability to understand the obligations of marriage as opposed to mere inability to comply with them. So there is a difference with inability to understand and inability to comply. Inability to understand is something which is cognitive. Okay, it is in the head. Okay, inability to comply is something which is in the will of a person, meaning you understood your obligations, but you simply refused to do your obligations. Okay? To constitute psychological incapacity, the personality disorder must be characterized by gravity, juridical antecedents, and incurability. In the Molina case, incurability as well as gravity could be established by the psychologist or psychiatrist, while juridical antecedents must be established by persons who knew the psychologically incapacitated spouse during his early or formative years. It must be grave or serious, such that the party would be incapable of carrying out the ordinary duties required in marriage. There is no requirement that the person to be declared psychologically incapacitated be personally examined by a physician. So most likely, in cases of nullity under Article 36, the spouses are already estranged. So they already ceased communication with each other. So most likely, the spouse alleged to be psychologically incapacitated would not cooperate or would not appear before the clinic of the psychiatrist or the psychologist to be examined. However, there are several cases starting with Marcos versus Marcos that states that the personal examination by the psychiatrist of the psychologically incapacitated spouse is not a requirement. Okay? Non-examination of one of the parties would not automatically render as hearsay or invalidate the findings of the examining psychiatrist. So the totality of the behavior of one spouse during the cohabitation and marriage is generally witnessed mainly by the other party. So the effect of the psychological incapacity is generally felt and witnessed by the people around him or around her. Okay, so it would not invalidate the finding of the psychologist with respect to gravity and incurability of the psychological incapacity. Okay. The court rules in Gantan that the totality of evidence presented established that the respondent is afflicted with psychological incapacity, which hindered him from performing his duties as a husband. Okay? Petitioner testified on how respondent failed to observe mutual love, respect, and fidelity. She averred that they were no longer together and that the respondent had abandoned her and is living with his paramour. He had been abusing her physically, mentally, emotionally. He had been having illicit affairs with older and married women. He often mocked and insulted her. He frequently hurt or assaulted her physically, even causing her to get hospitalized and suffer a miscarriage. All this reflect his lack of remorse, deception, impulsivity, irritability, aggressiveness, physical assault and intimidation, reckless disregard for the safety of others, unwillingness to meet normal standards for work, support, and parenting, and failure to conform to social norms with respect to lawful behaviors. Dr. De La Cruz showed a medical link between the respondent's psychological incapacity and the acts that manifest the same. Her testimony amply proved that respondent's antisocial personality disorder made him deceitful, irresponsible, remorseless, unfaithful, violent, ill-tempered, and inconsiderate of others' safety. It was so grave to the point that it distorted his concept of marital relationship, thus incapacitating him to fully comprehend, assume, and carry out essential marital obligations. Again, I wish to emphasize that a person who is psychologically incapacitated has a distorted concept of marital relationship. He does not fully understand or he has a misconception of what are the obligations of a married person are. Okay? Thus making him incapable of fulfilling or complying with essential marital obligations. Also, she testified that its root cause existed during the respondent's teen years, arising from his family setup. Respondent's parents, being overseas workers, left him under the care of his uncle. His family became dysfunctional over the years, resulting in his loss of emotional and psychological continuity of contact and attachment. Respondent carried with him this dysfunctional concept of family onto his engagement and later on marriage with petition. Okay. We now move to the case of Republic versus Calinko. Okay, we have here a case of a person allegedly afflicted with histrionic as well as borderline personality disorder. So the manifestation of the psychological incapacity of the wife is gossiping, reading comic books, and infidelity. Okay. Ariel, the husband, left the family home after Cynthia threw a knife at him. So he filed a case for declaration of nullity, and the psychologist found out that Cynthia was suffering from borderline personality disorder with histrionic features. Okay. Jurisprudence again, the Supreme Court said that jurisprudence defines psychological incapacity to no less than a mental, not physical, incapacity that causes a party to be truly incognitive of the basic marital covenants that must concomitantly be assumed and discharged by the parties to a marriage. It ought to pertain to only the most serious cases of personality disorders that clearly demonstrate the parties' utter insensitivity or inability to give meaning and significance to the marriage. So in this case, Ariel presented the medical assessment of the psychiatrist who found that Cynthia is suffering from borderline with histrionic personality disorder. However, the court found that it refuses to accept as credible the assessment of Dr. Lopez as there was no other evidence which established the juridical antecedents, gravity, and incurability of Cynthia's alleged incapacity. It is necessary to provide corroborative evidence to exhibit the required legal parameters. So the lesson to be learned in the case of Calinko is that you cannot rely only on the testimony of the psychologist or the psychiatrist. There has to be other witnesses who would factually validate or corroborate the testimony of the psychologist or the psychiatrist relative to the gravity, incurability, and juridical antecedents of the alleged psychological incapacity. In this case, uh, the ones who testified are friends of the couple for more or less 30 years, but they have not known the psychologically incapacitated spouse longer than such period of time. Neither was it shown that Ariel or the spouse likewise had personal knowledge of Cynthia's family background. They could not have known Cynthia's childhood nor the manner as to how she was raised. Okay, again, to the point of being repetitious, okay, the Supreme Court said psychological incapacity must be more than just a difficulty, refusal, or neglect in the performance of marital obligations. It is not enough that a party prove that the other failed to meet the responsibilities and duties of a married person. Okay. We now go to the landmark case of Tan-Andal versus Andal. Why is this a landmark case? Because previously, um, in evaluating psychological incapacity cases, the trial courts use Molina as its benchmark or guideline. Okay, now in Tan-Andal, the Supreme Court found it appropriate to revise the guidelines set forth in Molina. So let us examine the facts of Tan-Andal. Okay. In this case, it was alleged that Mario, the husband, was psychologically incapacitated to comply with essential marital obligations. The primary manifestation of the alleged psychological incapacity was the drug use of Mario. That there was even a time when Mario even used drugs in front of their child. So Mario's narcissistic antisocial personality disorder, which was found by the psychologist, was alleged to be grave with juridical antecedents and incurable. So Mario does not have enough ego strength to effectively self-regulate and face the marital task and relational stressors. And there were substrates in Mario's development which made him feel inadequate and bitter. Okay. Mario needed to have power over others to save face. Now, in Tan-Andal, the Supreme Court said that it is time for a more comprehensive but nuanced interpretation of what truly constitutes psychological incapacity. Okay. In Tan-Andal, the Supreme Court laid down the new uh, quantum of evidence that is needed to prove psychological incapacity. Previously in Molina, what was being employed is the totality of evidence. In Tan-Andal, the Supreme Court revised it, saying that in establishing psychological incapacity, there is a need to produce clear and convincing evidence. The plaintiff's spouse must prove his case with clear and convincing evidence. Okay. A family can be found. Not that. Okay. The term psychological incapacity was first defined by the court in Santos, the seminal case of Santos, as a mental, not physical incapacity to comply with essential marital obligations. The term was confined to the most serious cases of personality disorders which is clearly demonstrative of an utter insensitivity or inability to meaning and significance to the marriage. This root cause must be medically or clinically identified and sufficiently proven by experts. So this court now categorically abandons the Molina guideline. Psychological incapacity, according to Tan-Andal, is neither a mental incapacity nor a personality disorder that must be proven through expert opinion. There must be proof, however, of the durable or enduring aspects of a person's personality called personality structure, which manifests itself through clear acts of dysfunctionality that undermines the family. So you must remember that in Tan-Andal dispenses with the need to produce a psychologist or a psychiatrist that would establish the psychological incapacity as a mental disorder or as personality disorder. However, there is again a need to prove the durable or enduring aspects of personality called personality structure, which manifests clear acts of dysfunctionality that undermines the family. The spouse's personality structure must make it impossible for him to understand and to comply with his essential marital obligations. So proof of these aspects of personality need not be given by an expert. Ordinary witnesses who have been present in the life of the spouses before the latter contracted marriage may testify on behaviors that they have consistently observed from the incapacitated spouse. So when you say durable, it means it existed over time. And it is more or less permanent because it manifested consistently through time. Okay? And these manifestations of personality through time must be something which undermines the family, making it impossible for that person to comply with essential marital obligations. So there is no more need to produce an expert to prove the personality structure. Okay. Further, there will be no more need to label a person as having a mental disorder just to obtain a degree of knowledge. A psychologically incapacitated person may not be shamed and pathologized for what could have been a simple mistake in one's choice of intimate partner. A person's psychological incapacity to fulfill his marital obligation should not be at the expense of one's dignity, because it could very well be that he did not know that the incapacity existed in the first place. Difficult to prove as it may be, a party to a nullity case is still required to prove juridical antecedents because it is an explicit requirement of the law. Okay, so there is a need to prove that the incapacity existed or antedated the marriage. Okay? Is there a need to prove incurability? Yes, there is a need to prove incurability, but not in the medical, but in the legal sense. So there is no more need to produce a psychiatrist in order to establish that the psychological incapacity is incurable. Okay, but there is still a need to prove incurability. This means that the incapacity is so enduring and persistent with respect to a specific partner and contemplates a situation where the couple's respective personality structures are so incompatible and antagonistic that the only result of the union would be the inevitable and irreparable breakdown of the marriage. An undeniable pattern of such persisting failure to be a present, loving, faithful, respectful, and supportive spouse must be established so as to demonstrate that there is a need, indeed, a psychological anomaly or incongruity in the spouse relative to the other. How about gravity? Of course, there is still a need to prove gravity. Again, mere characterological peculiarities, changes, occasional emotional outbursts are excluded. It must be shown that the incapacity is caused by a genuinely serious psychic cause. Okay. To summarize, psychological incapacity consists of clear acts of dysfunctionality that show a lack of understanding and concomitant compliance with one's essential marital obligations due to psychic causes. It is not a medical illness that has to be medically or clinically identified. Hence, expert opinion is not required. As an explicit requirement of the law, the incapacity must be shown to have been existing at the time of the celebration of the marriage and is caused by a durable aspect of one's personality structure, one that was formed before the parties got married. It must be shown to be caused by a genuinely serious psychic cause. To prove psychological incapacity, a party must present clear and convincing evidence of its existence. So, in a nutshell, that is the doctrine of Tan-Andal. Okay, it dispenses with the requirement of presenting an expert witness to prove uh, the root cause of the psychological incapacity. What is important is the personality structure that is enduring. And that personality structure made it impossible for the person to understand and necessarily to comply with essential marital obligations. And this condition antedated the marriage and is because of a psychic. Okay? In this case, it is true that Dr. Garcia gave the expert opinion. Uh, ex, uh, okay. In this case, the Supreme Court said that the drug addiction is a ground for legal separation, but can also be considered as a manifestation of psychological incapacity. So the totality of evidence presented by Rosana convincingly proved that Mario's drug abuse was of sufficient durability that antedates the marriage. Part of the marriage is accepting a person for who they are, including their addictions. However, in Mario's case, his persistent failure to have himself rehabilitated, even bringing his child into a room where he did drugs, indicates a level of dysfunctionality that shows utter disregard of his obligations, not only to his wife, but also to his child. Okay? Um, let us close Tan-Andal with these very inspiring words from Senior Associate Justice Yonen. We are not blind to the reality that the person may be truly psychologically incapable for the other from the beginning. Should there be a great need to part for the reasons we have stated, courts can lead the way to make parting less bitter, minimize animosity, and make lives more forward-looking for those most affected. Parting is already a sort. It need not be more than what it already is. Okay? We have the case of Padua versus Padua. The Padua case was decided after Tan-Andal. So it already reiterated or encapsulated or summarized the Tan-Andal guidelines. Okay, so in this case, Maria and Joselito were married. Okay, however, after a few years, Maria filed a nullity of marriage case on the ground of psychological incapacity. Now, what are the manifestations as found by the psychologists? It is sexual perversion. Okay, according to Dr. Villegas, she diagnosed Joselito with a personality disorder of a sexual deviant or perversion based on Maria's narration. Okay, the root cause of Joselito's disorder is traceable to his wretched childhood, inasmuch as Joselito spent his youth with a cruel father and a very protective mother. So, in Padua, it summarized the Tan-Andal guidelines as follows. The psychological incapacity must be shown to have been existing at the time of the celebration of the marriage, so that is juridical antecedents. It is caused by a durable aspect of one's personality structure, one that was formed prior to their marriage. It is caused by a genuine, serious psychic cause, and it is proven by clear and convincing evidence. So in this case, the Supreme Court said the totality of evidence presented by Maria found that the same was miserably wanting to sustain the conclusion that Joselito was psychologically incapacitated to perform the basic obligations of marriage. There was no information how Joselito reacted towards the supposed contracting personalities of his parents during his formative years. Neither was there any account as to how the said contrasting parenting behavior affected Joselito's emotional growth. There was nobody who testified on vital information regarding his personality structure, upbringing, and child. So in Padua, there is a need to prove juridical antecedent. There must be witnesses who could testify on the respondent's behavior during his formative years or before he entered into the marriage. So in this case, the court found that the couple's irreconcilable sexual preferences would in no way amount to psychological incapacity. Joselito's inability to sexually satisfy his wife because the latter prefers the conventional way would not be taken to mean that Joselito is psychologically incapacitated. Sexual incompatibility is not a ground for declaration nullity of marriage. It is not enough to prove that a spouse failed to meet his responsibilities as a married person. Incapacity must be so enduring and persistent with respect to a specific partner that the only result of the union would be the inevitable and irreparable breakdown of the marriage. Okay? The last case on psychological incapacity, Santiago versus Santiago. During their marriage, instead of experiencing marital bliss, their relationship was fraught with quarrels. So petitioner and respondent separated because they could no longer stand each other. So respondent filed a petition for nullity, and the psychiatrist, okay, found her to be suffering from dependent personality disorder and the petitioner from narcissistic personality disorder. So the issue is whether or not the parties' marriage should be nullified on the ground of psychological incapacity. Okay, again, the Supreme Court laid down the requirements. Okay, first is gravity. It must be grave and serious, such that the party would be incapable of carrying out the duties required of marriage. Second would be juridical antecedents. It must be rooted in the history of the party antedating the marriage. And incurability, it must be incurable, or even if it were otherwise, the cure would be beyond the means of the party. So the Supreme Court in this case held that the totality of the evidence presented failed to sufficiently establish the respondent's psychological incapacity. In this case, there is a need. The Supreme Court emphasized that the link between the respondent's acts to his psychological incapacity was not established. Even if it is assumed that respondent truly had difficulties in making everyday decisions without excessive advice or reassurance coming from other people, the report fails to prove that the said difficulties were tantamount to a serious psychological disorder that would render him incapable of performing essential marital obligations. A clear and understandable causation between the parties' condition and the party's inability to perform essential marital duties must be shown. Okay? While respondents' womanizing caused the couple frequent fights, such was not established to be caused by a psychological illness. Records reveal that when petitioner discovered respondent's affair for the first time, the latter immediately severed it. They would also eventually reconcile and live together after their fights. So you must remember in this case, the manifestation was the extramarital affairs of the husband. But when the wife confronted him about it, he realized his marital obligations of fidelity to the wife. So he cut the affair. He stopped the affair, went back and reconciled with his wife. And then subsequently it was repeated again. So it was not non-cognizance, but maybe a mere difficulty, okay, to fulfill the marital obligations. But the mere fact that he cut his ties with his paramour and went back to his wife means that he knew his basic marital obligations and he is trying his best to comply with it. So that is not the psychological incapacity that is contemplated under the law. Okay? The psychological incapacity under Article 36 means a personality structure that does not understand or that has a distorted concept of marital obligation. Okay? So if that is the case, he knew that it was his obligation. It was his obligation to remain faithful to his wife. That is the reason why he severed the relationship. So it means that he understood his duties as his spouse. Okay? Okay. So that caps psychological incapacity under Article 36. We now go to the other types of void marriages. Article 37 speaks of incestuous marriages. Okay, these marriages are incestuous and are void from the beginning between ascendants and descendants of any degree. So we are speaking of ascendants and descendants in the direct line, meaning the great-great-great-grandfather, great-great-grandchild, okay? No matter how many degrees they are apart from each other, marriage between and among those people are considered as incestuous and therefore void from the beginning. Between brothers and sisters, whether of the full or half blood. So what is important here is the presence of blood relationship. It is irrelevant whether it is full or half. What is important is they are related by blood. It does not matter whether they are brothers, or maternal siblings or paternal siblings. What is important is they are related by blood. Okay? Article 38, on the other hand, speaks of marriages which are void ab initio by reason of public policy. What are they? Between collateral blood relatives, whether legitimate or illegitimate, up to the fourth civil degree. Okay, so you count the relationship. Remember, it is blood relatives have blood, meaning by consanguinity. So, if, for example, an example of a relative in the fourth civil degree is a first cousin. Of course, you know how to count the degree. So, you count. So, for example, how is it that my first cousin is related to me collaterally within the fourth civil? So, from me to my parent, that's one degree. Okay? From my parent to my grandparents, that's another degree. And then you go down from the grandparents to the mother of my cousin, that is another degree. So third, from the mother of my cousin to my cousin, that is another degree. So four. So you count the lines, that would be four. So it means 4 degrees. Okay? So if you are related by blood within the fourth degree, then that would be a void ab initio marriage. Okay? Between step-parents and step-children. Okay? Between parents-in-law and children-in-law. Between the adopting parent and the adopted child. Between the surviving spouse of the adopting parent and the adopted child. Why this on adoption? Between step-parents and step-children. Why? Because they're supposed to be treating each other as parent and child. So between parents-in-law and children-in-law, the same reason. Okay? With respect to adoption, okay, there is this legal fiction of relationship. So it is void by reason of public policy because you are supposed to treat each other as parent and child. Adopting parent and the adopted child, between the surviving spouse of the adopting parent and the adopted child. Why? Because adoption is supposed to be joint. Okay? And the spouse of the adopter is supposed to treat the adopted as a child. Okay? Between the surviving spouse of the adopted child and the adopter, between an adopted child and a legitimate child of the adopter. Why? Because they're supposed to treat each other as siblings. Between adopted children of the same adopter. And last, between parties where one, with the intention to marry the other, kill that other person's spouse or his or her own spouse. Okay? Okay. You have to remember that void marriages are not subject to prescription. Okay? The absolute nullity of a previous marriage may be invoked only for purposes of remarriage on the basis solely of a final judgment declaring such previous marriage void. That is what I am telling you a while ago in the case of Castillo versus Castillo that is under the civil code. Now, if you want to remarry or get married again, and you have a previous marriage, you have to first seek a declaration of nullity or an annulment of that marriage before you can enter into another marriage. Okay, we have the case of De Guzman versus Paul. A person cannot unilaterally declare his marriage void. The law provides that a judicial declaration of nullity is indispensable for purposes of remarriage. This is now under the family code. A declaration of an absolute nullity of a marriage is now explicitly required either as a cause of action or as a ground for defense. Where the absolute nullity of a previous marriage is sought to be invoked for purposes of contracting a second marriage, the sole basis acceptable in law to be free from legal infirmity is a final judgment declaring the previous marriage void. Okay, the case of De Castro versus De Castro. Okay, in this case, in lieu of a marriage license, they executed an affidavit of cohabitation stating that they have lived together as husband and wife for at least 5 years. Petitioner denied that he is married to respondent, claiming that their marriage is void on the ground that it was facilitated by a fake affidavit. So the Court of Appeals denied the appeal, prompted by the rule that a marriage is presumed to be subsisting until there is a judicial declaration of nullity. So the issue is whether the trial court had the jurisdiction to determine the validity of the marriage between petitioner and respondent in an action for support. So this is actually a collateral attack on the marriage. Okay. Can a void marriage be attacked collaterally, meaning not in a direct proceeding to annul or nullify the marriage, but in an indirect action, which is an action for support? The Supreme Court said yes, the validity of a void marriage may be collaterally attacked. However, other than for purposes of remarriage, no judicial action is necessary to declare a marriage an absolute nullity. For other purposes, such as but not limited to the determination of heirship, legitimacy, or illegitimacy of a child, settlement of estate, dissolution of property regime, or a criminal case, the court may pass upon the validity of marriage, even if in a suit not directly instituted, to question the state, as long as it is essential to the determination of the case. So remember, in void marriages, it can be attacked directly or collaterally. So even in another action, such as an action for support. And you can establish the nullity of the said marriage in that collateral action. Okay, we now go to declaration of presumptive death. Under Article 41, a marriage contracted by any person during the subsistence of a previous marriage shall be null and void, unless before the celebration of the subsequent marriage, the prior spouse had been absent for 4 consecutive years, and the spouse present had a well-founded belief that the absent spouse was already dead. In case of disappearance where there is danger of death, an absence of 2 years shall be sufficient. Okay, so you must remember that if a person has been absent for 4 consecutive years and you are married to that person, what should you do? How do you turn and you want to get married again? How do you get married again? Can you get married again? Okay, considering that your spouse had been absent for 4 consecutive years. The answer is you file a declaration of presumptive death. Okay, but it can only be invoked for purposes of remarriage. Now, what if that spouse turned out not to be dead, but simply had in movies, they say that the person had amnesia. So, and then subsequently he reappeared. What can he do in order to resume living with his wife. Okay, he simply files an affidavit of reappearance. The subsequent marriage shall be automatically terminated by the recording of an affidavit of reappearance of the absent spouse unless there is a judgment annulling the previous marriage or declaring it void ab initio. Okay, Article 43 speaks of the effect of the termination of the subsequent marriage. So what would be the effect? What if there are already children of the second marriage? Okay, the children conceived prior to its termination shall be considered as legitimate. The absolute community of property shall be dissolved and liquidated. Donations by reason of marriage shall remain valid. The innocent spouse may revoke the designation of the other spouse who acted in bad faith as a beneficiary in any insurance policy, and the spouse who contracted the subsequent marriage in bad faith shall be disqualified to inherit from the innocent spouse by testate or intestate succession. Okay? Um, there are several cases regarding declaration of presumptive death, one of which is Republic versus Penal. But the common thread that runs through all those cases is that, okay, for a petition to declare a person as presumptively dead to be granted, there must be always a well-founded belief, okay, that the absent spouse is already dead. Now, in jurisprudence, the Supreme Court has defined what a well-founded belief is. The well-founded belief requires that the present spouse to prove that his belief was the result of diligent and reasonable efforts to locate the absent spouse, and that based on these efforts, he believes that under the circumstances, the absent spouse is already dead. It necessitates exertion of active effort, not a passive one. The mere absence of the spouse for such period, lack of any news that such absentee is still alive, failure to communicate, or general presumption of absence would not be sufficient. So it must be an active effort to locate the absent spouse. Okay? To meet the requirements of the law, the present spouse must allege and prove that his belief is the result of proper and honest to goodness inquiries and efforts to locate the absent spouse to determine whether he is alive or not. When Reneto's family members denied knowing his whereabouts, respondent took it as gospel truth without even bothering to inquire from the neighbors or other disinterested persons. The present spouse's bare assertion that he inquired from his friends or from the relatives of his absent spouse is insufficient, especially when the names of the persons from whom he made inquiries were not identified. It there being no basis of the well-founded belief that Reneto is already dead, the petition was denied. Okay? Again, Republic versus Quiñones is again a case on declaration of presumptive death. Uh, in this case, the Supreme Court laid down the essential requirements for declaration of presumptive death for purposes of remarriage. Number one, the absent spouse has been missing for 4 consecutive years or 2 consecutive years if the disappearance occurred when there is danger of death. So the period of absence. The second requirement is the purpose. Okay, the present spouse wants to remarry. Okay, third requirement is well-founded that the absentee is dead. Okay, and fourth requirement is the filing of a summary proceeding to declare the presumptive death of the absent. Okay, the requirement, again, of well-founded belief can only be discharged upon a showing of proper and honest to goodness inquiries to ascertain not only the absent spouse's whereabouts, but more importantly, that the absent spouse is still alive or is already dead. To be able to comply with this requirement, the present spouse must prove that his belief was the result of diligent and reasonable efforts to locate the absent spouse. It requires exertion of active effort and not a mere passive one. Okay? Okay, Machas versus Republic. If your purpose is not remarriage, okay, but other purposes, there is no need to file a summary proceeding the uh, to declare your spouse as absent. You can rely on the presumption established in our rules on it. So in this case, uh, in order to comply with the requirements for the release of her husband's death benefits, he filed a petition for presumptive death. Okay, however, the Supreme Court said the petition for presumptive death is not an action that would have warranted the application of Article 41 because the petitioner was not seeking to remarry. A reading of Article 41 shows that the presumption of death is only applicable for the purpose of contracting a valid subsequent marriage. Given that her petition for presumptive death was not filed for the purpose of remarriage, petitioner was relying on the presumption of death under 390 or 391 of the Civil Code as the basis for her petition. Articles 390 and 391 of the Civil Code expresses the general rule regarding presumption of death for any civil purpose. It must be stressed that presumption of death under Articles 390 and 391 of the Civil Code arises by operation of law without need of a court declaration once the factual conditions are established, hence requiring the claimant to further secure a court declaration in order to establish the presumptive death of a missing soldier is not proper and contravenes established jurisprudence. So lesson to be learned, you only file a petition to declare someone presumptively dead if your purpose is remarriage. If it is for other purposes, there is no need for a court declaration. You just rely on presumption of death under Articles 390 and 391 of the Civil Code. Okay. The case of Santos versus Santos. Okay, in this case, the Supreme Court said the proper remedy for a judicial declaration of presumptive death, okay, is on the ground of extrinsic fraud, is an action to annul judgment. Okay, is an affidavit of reappearance not enough? Okay, an affidavit of reappearance is not the proper remedy when the person declared presumptively dead has never been absent. So Santos versus Santos speaks of a case when a person was declared presumptively dead when he has not, in fact, been absent. Okay, because in this case, the wife claimed that it was the husband who left the conjugal abode. Okay, and then the husband found another woman and then wanted to marry this woman. So what the husband did is to file a petition to declare the wife as presumptively dead. The wife said that how can I be presumptively dead when I have not been absent for 4 consecutive years? It was actually him who left our house. Okay. Now, can the wife just file an affidavit of reappearance? So what is the remedy that the wife can avail of if the petition to declare her presumptively dead was granted? Supreme Court said he can file a petition for annulment of judgment on the ground of extrinsic fraud. Whether the Court of Appeals erred in dismissing the petition for annulment of judgment for being the wrong remedy. Okay, although this is somewhat procedural in nature, okay, the Supreme Court said the termination of the subsequent marriage by reappearance is subject to several conditions. the non-existence of a judgment, annulling the previous marriage or declaring it void as short, recording in the civil registry of the residence of the parties to the subsequent marriage of the sworn statement of fact and circumstances of reappearance, due notice to the spouses of the subsequent marriage, and the fact of reappearance must either be undisputed or judicially determined. Hence, the subsequent marriage may still subsist despite the absent or presumptively dead spouse reappearance if the first marriage has already been annulled, if the sworn statement of the reappearance is not recorded, if there is no notice to the subsequent spouses, and if the fact of reappearance is disputed in the courts of law. A subsequent marriage contracted in bad faith, even if it was contracted, with a declaration of presumptive death, lacks the requirement of a well-founded belief that the spouse is already dead. The first marriage will not be considered as validly terminated. Marriages contracted prior to the valid termination of a subsequent marriage are generally considered bigamous and void. Only a subsequent marriage contracted in good faith is protected by law. So the provision on reappearance in the family code as a remedy, to effect the termination of the subsequent marriage does not preclude the spouse who was declared presumptively dead from availing of other remedies. This court recognized that a subsequent marriage may also be terminated by filing an action in court to prove the reappearance of the absentee and to obtain a declaration of dissolution or termination of the subsequent marriage. Okay? Since an undisturbed subsequent marriage under the family code is valid until terminated, the children of such marriage shall be considered legitimate. If it is terminated by mere reappearance, the children of the subsequent marriage conceived before the termination shall still be considered legitimate. Moreover, a judgment declaring presumptive death is a defense against the prosecution for bigamy. However, a petition for declaration of absolute nullity may be filed solely by the husband or the wife. This means that even if Celerina is a real party in interest who stands to be benefited by the outcome of the action to nullify the second marriage, this remedy is not available to her. Therefore, for the purpose of not only terminating the subsequent marriage, but also to nullify the effect of the declaration of presumptive death and the subsequent marriage, mere filing of an affidavit of reappearance would not be sufficient. Celerina's choice to file an action for annulment of judgment will therefore lie. Okay. Article 45 speaks of voidable marriages. Okay. A marriage may be annulled for any of the following causes existing at the time of the marriage. Okay, we must remember that voidable marriages are those marriages that are valid until annulled. Okay, so what are the causes or what are the cases of voidable marriages? First, that the party in whose behalf it is sought to have the marriage annulled was 18 years of age or over, but below 21, and the marriage was solemnized without the consent of the parent, guardian, or person having substitute parental authority. Okay, so remember the age 18 to 21. If you are between those ages and you are getting married, you have to have the consent of your parents, guardian, or person with substitute parental authority. However, considering that it is merely voidable, it is subject to ratification. How can it be ratified? Unless, after attaining the age of 21, such party freely cohabited with the other and both lived together as husband and wife. So, after attaining the age of 21, if you continue to live with your spouse, then that constitutes ratification. Okay, second, that either party was of unsound mind, unless such party, after coming to reason, freely cohabited with the other as husband. There was a defect in the consent. Because if you are of unsound mind, then you do not have the necessary mental facility to recognize that you are entering into a marriage. Third, that the consent of either party was obtained by fraud unless such party with full knowledge of the facts constituting the fraud freely cohabited with the other as husband and wife, that the consent of either party was obtained by force, intimidation, or undue influence, unless the same having disappeared, such party freely cohabited with the other as husband and wife. So, 2, 3, and 4 specs of devices or defects in consent: force, intimidation, undue influence, fraud, unsound mind. Okay? Number 5, that either party was physically incapable of consummating the marriage with the other, and such incapacity continues and appears to be incurable. You must remember that number 5 speaks of the physical inability to have sexual relationship with the spouse. It must be physical in nature and appears to be incurable. Okay, and number 6, that either party was afflicted with a sexually transmissible disease found to be serious and appears to be incurable. Okay, 5 and 6 also are defects in the consent, because if you knew that that person is physically incapable of consummating marriage or is afflicted with a sexually transmissible disease, which is found to be serious and incurable, you would not have given your consent to the marriage. So these one grounds from 1 to 6 constitute defects in the consent, okay, which if not ratified would be a ground to declare the marriage, to would be a ground to annul the marriage. Okay. Article 46 speaks of the instances or circumstances that constitutes fraud. What constitutes fraud? First, non-disclosure of a previous conviction by final judgment of the other party of a crime involving moral turpitude. So non-disclosure means concealed. Okay, there is a necessity that the spouse has been convicted by final judgment of a crime involving moral turpitude. Okay, if the case is still pending, there is still no final judgment, non-disclosure of that case would not constitute fraud. Okay. It must be a conviction by final judgment, and it must be to a case involving moral turpitude. If, for example, a person has been convicted of a crime, such as reckless imprudence resulting to physical injuries, would a non-disclosure of the said crime amounts to fraud, that could be a ground for nullifying, for annulment of marriage? The answer is no, because that crime is not a crime involving moral turpitude. Number 2, concealment by the wife of the fact that at the time of the marriage, she was pregnant by a man other than her husband. So the crucial thing to remember in number 2 is she must be pregnant at the time of the marriage, not before, not after. Okay? It must be at the time of the marriage. She was pregnant by a man other than her husband, by a child who was sired by a man other than her husband. Okay, number 3, concealment of a sexually transmissible disease, regardless of its nature, existing at the time of the marriage. Okay, so you must remember that in Article 45, paragraph 1, the sexually transmissible disease appears to be serious and incurable. Okay? In fraud, to constitute fraud under Article 46, the sexually transmissible disease need not be serious and incurable. The only requirement is that it must be existing at the time of the marriage. Okay, number 4, concealment of drug addiction, habitual alcoholism, homosexuality or lesbianism existing at the time of the marriage. So, there is a requirement that they must exist at the time of the marriage. Okay, why? Because had the other spouse known that he was hooked to drugs, is an alcoholic, homosexual, or a lesbian, he would not have agreed to enter into the marriage. Okay? So you must remember that no other misrepresentation or deceit as to character, health, rank, fortune, or chastity shall constitute such fraud. That could be a ground for annulment of marriage. Remember, not all kinds of fraud is a ground for annulment of marriage. Um, what is not included is therefore excluded. So the fraud that could annul the marriage is only limited to numbers 1 to 4 of Article 46. Okay. What is the period to file action for voidable marriages? The action for annulment of marriage must be filed within the said period for causes under Article 45(1) by the party whose parent or guardian did not give his consent within 5 years after attaining the age of 21, or by the parent or guardian or person having legal charge of the minor at any time before such party reaches the age of 21. For number 2 of Article 25, by the same spouse who had no knowledge of the other's sanity, or by any relative guardian or person having legal charge of the same, or by the insane spouse during a lucid interval, for causes mentioned in number 3, Article 45, by the injured party within 5 years after the discovery of the fraud, for number 4, by the injured party within 5 years from the time the force, intimidation, or undue influence disappeared, and for causes under number 5 and 6, by the injured party within 5 years after the marriage. Okay, let us go to Republic versus Villacorta. So this is a case involving fraud. Okay, so the party in this case had a concealed pregnancy. Did the concealed pregnancy of the wife constitute fraud that vitiated the consent? The Supreme Court said the essence of fraud is the non-disclosure of the present pregnancy of the wife. The pregnancy must exist at the time of the celebration of the marriage. If the wife had previous relations with other men, and as a consequence, she became pregnant or bore a child previously, the concealment will not be a ground for annulling the marriage if at the time the marriage was celebrated, the wife was not pregnant. Non-disclosure of husband's premarital the intention of Congress is to confine the circumstances that can constitute fraud as a ground for annulment of marriage to the 3 cases of all. Fraud is the only one which is given special treatment. To stress further, the intention is to enumerate the fraud to the enumeration, to limit the fraud to enumeration stated in Article 46. Non-disclosure of a husband's premarital relationship with another woman is not one of the enumerated circumstances that would constitute a ground for annulment. Okay? As the purported fraud does not squarely fall under Article 46, it cannot serve as a ground for uh, legal versus template. In this case, this is a case of homosexuality. Lilia admitted that in the pre-trial, said prior subsisting marriage, but claimed that said marriage was null because she were forced to enter the marital. There is no need for the petitioner to prove that her first marriage was initiated by force, since the marriage will not be void but merely voidable. Since no annulment has yet been made, it is clear that when she married the respondent, she was still validly married to her first husband. Consequently, her marriage to respondent is void. No, that was not the homosexuality case. The homosexuality case was Almelor versus the RTC of Castillo. So the ground for annulment of marriage in this case is the concealment of homosexuality. Now, the RTC granted the petition, uh, but not based on Article 36, but on Article 46. However, the Supreme Court said no sufficient proof was presented to substantiate the allegation that Manuel is a homosexual and that he concealed this to his wife at the time of their marriage. The lower court considered the public perception of Manuel's sexual preference without corroboration of witnesses. Also, it took cognizance of Manuel's peculiarities and interpreted it against his sexuality. Nowhere in the said decision is it proven by preponderance of evidence that Manuel was a homosexual at the onset of his marriage and that he deliberately hid such fact to his wife. It is the concealment of homosexuality and not homosexuality per se that vitiates the consent of the innocent party. To reiterate, homosexuality per se is only a ground for legal separation. It is its concealment that serves as a valid ground to annul the marriage. Concealment in this case is not simply a blanket denial, but one that is constitutive of fraud. It is this fundamental element that respondent failed to. Okay? We now go to the last case of Anaya versus Palaroan. So the issue in this case is whether or not the non-disclosure to a wife by her husband of his relationship with another woman is a ground for annulment of marriage. Again, fraud as a vice of consent is limited exclusively to those kinds or species of fraud enumerated under Article 46. Enumerating the specific frauds, misrepresentation as to identity, non-disclosure, previous conviction, concealment of pregnancy, making it clear that Congress intended to exclude all other frauds or deceit. Non-disclosure of a husband's premarital relationship with another woman is not one of the enumerated circumstances that would constitute a ground for annulment. While a woman may detest such non-disclosure of premarital lewdness or feel having been cheated into giving her consent to the marriage, nevertheless the law does not assuage her grief after her consent was solemnly given. For upon marriage she entered into an institution in which society and not herself alone is interested. The lawmaker's intent being plain, the court's duty is to give effect to the same, whether it agrees with the rule or not. Okay, so the case of Hernandez versus Court of Appeals. Private respondent engaged in extreme promiscuous conduct during the latter part of 1986. So sexually transmissible disease. As a result, he contracted gonorrhea. So there was a decision dismissing the petition for annulment of marriage. Okay. The Supreme Court said that the other forms of psychosis, if existing at the inception of the marriage, such as the state of a party, being of unsound mind, concealment of drug addiction, habitual alcoholism, homosexuality or lesbianism, merely renders the marriage voidable pursuant to Article 46. If drug addiction, alcoholism, homosexuality should occur only during the marriage, they become mere grounds for legal separation. However, private respondents, habitual alcoholism, sexual infidelity or perversion, and abandon do not by themselves constitute grounds for a finding that he is suffering from psychological incapacity. It must be shown that these acts are manifestations of a disordered personality, which make the respondent unable to discharge the essential obligations of the maritals. You must remember that in all cases where annulment or declaration of nullity, the fiscal is required to conduct an investigation and submit a non-collusion report. Because judgment by default in actions of this nature is not allowed. So that's it for today. Thank you for listening.